Amrish sir, shall we start? 98 participants are there.
Yes.
Okay, sir. A very good morning to one and all. I, Chitra Gupta, welcome you all on behalf of Lloyd Group of Institutions, Greater Noida, Uttar Pradesh, to the first Impact Lecture session on Overview of Intellectual Property Rights, sponsored by Innovation Cell of Ministry of Education and AICTE. Today's session will comprise of two talks, 1.5 hour duration each. First one entitled Understanding the Basics of IPR and Patent Drafting by Dr. Amrish Chandra, and second one, Patentability Assessment and Structuring a Patent Document by Dr. Rajiv Kapoor. The idea is to give deep insights into IPR and impart knowledge on various aspects like patentability assessment, patent drafting, and relevant documentation so that the students and faculty members are able to protect their innovative ideas and products and get benefited with this. On behalf of all the organizers and coordinators, I would like to express gratitude to AICTE and MIC for having given us this opportunity. At the outset, I would like to extend my heartfelt greetings to everyone on this auspicious day of Guru Purnima. Nothing better to have this workshop on such a day. कहते हैं गुरु की उम्र से नहीं बड़ी होती, ईयर्स में नहीं बड़ी होती, रादर ज्ञान से बढ़ती है। तो इसी मनोकामना के साथ कि इस ज्ञान के पथ पर हम सर निरंतर अग्रसर रहें, हम ये वर्कशॉप स्टार्ट कर रहे हैं। Before I hand over to Dr. Amrish, I would like to put forth a few points. We welcome all the delegates, but there are a few rules for smooth conduct of this session. We would request all the participants to keep themselves on mute while the session is in progress. You can put your queries during the session in the chat box with your names and affiliation. The queries will be addressed by the speaker at the end of their talk. Also, I would like to apprise all the participants that as per the norms of the sponsors of Impact Lecture sessions, there will be a small assessment quiz at the end of the session comprising of 10 MCQs. And certificates will be granted to only those participants who are present in both the sessions and score minimum of 50% in the assessment quiz. The links for the quiz will be shared at the end of the session and you will be given 15 minutes to submit your responses. Besides, there is a compulsory feedback from all the participants. Again, this will be shared in the form of Google form and all the delegates would be expected to submit it along with their quiz responses. So without taking any more time, I would like to give a brief introduction of our speaker today, Dr. Amrish Chandra. Dr. Amrish is an established academician, a research scientist, and a registered patent agent with Indian Patent Office. He has extensive experience of 20 years and is associated with Amity Institute since 2011. Dr. Amrish did his master's in pharmacy from Birla Institute of Technology, Mesra in 2002. A GATE scorer with 92.32 percentile, he did his PhD in transdermal drug delivery system in pharmaceutical sciences. His research profile includes more than 100 publications with more than 1300 citations and an H index of 18, I-10 index of 29 and cumulative impact factor of 80 plus. Sir has supervised 8 PhD and 25 PG students and has to his credit a DST sponsored Indo-Hungary project worth 1.7 crore and an Italian consultancy project. He has authored 1 book with Springer and 3 book chapters. So with that, sir, a warm welcome to you. We would like to present a virtual bouquet to you. So welcome, sir, and over to you.
Thank you very much. Yeah, thank you very much, ma'am. Thank you. Okay. So we have a very nice August gathering of more than 100 people over here, and I welcome all of you to this today's topic, understanding IPR and patent drafting, basically. I'm from MIT University. It's a sprawling big campus. So you can, if you are from Noida, Greater Noida region, you must have heard a lot about it. And this is one of my Indo-Hungarian research groups, and where we went in 2017, 18, 19. So we could travel to Hungary, and we filed some really good number of patents, and we had a lot of publications from this research group that we have in Hungary. And then we have another good collaboration with Dr. Maria. She's from Italy. So it's an Indo-Italy collaboration that we also have over there. I am passionate about improving academic output. So we are all from academics, okay, and it's my duty, and I understand. I take it as my duty, basically, and my obligation to help out each and every person who is having a passion for innovation and research, and if they want to go for patent filing or IPR or any kind of thing, it's my passion to help them out with whatever I can to the best of my ability. And we have filed a lot of patents for other people, and they have also got successful grants. So probably I'm able to do something for them. And when we talk of
सर जस्ट
intellectual,
एक्सक्यूज मी
yeah,
सर आपकी वॉइस थोड़ी सी क्लियर नहीं है, कुड यू बी अ बिट लाउडर, थोड़ा सा साउंड आउटपुट अपना बढ़ा लेंगे तो अच्छा रहेगा.
okay. Am I audible now?
Yeah,
It's
yeah,
fine.
it's better, it's better, it's better.
Yeah. So when we talk of intellectual property, the intellectual property is very much similar to the normal property that you have. So when you talk of property, it is either movable or immovable. And when you talk of patents, it is tangible or intangible properties. Okay. So similarly, like the way you want to buy a house, you go and think of buying a car or a bike or a jewelry. तो आप क्या करते हो? What is the process? So if you want to buy a house or you want to buy a car, what you will do? You will search the market. You will see which is the area which is most likely to grow in the future, or you will find an area which is already very populated or very posh, you know, and according to your needs you will find your location. So there is someone who might want to buy a house in Greater Kailash or South Ex, or somebody would like to buy a house in Worli, Mumbai. There is someone else who would want to buy a house at such a place which is not well traveled right now, but down the line after 5 years or 10 years, that area is going to have a very lot of potential to grow. So depending on your need and your thought process, your requirements, you will find out a land which is most suitable for you. Once you find out the land, you will just check all the details, whether this property is already owned by someone else or not, whether it is a disputed property or not. And if everything is well clear and everything is there, you will see if this you can register that property or not. Okay. So if it is registrable, then you go and buy that property, you register the property on your name, you build a house or a commercial complex or whatever it is. And once you have made this property, you will have an option, like either you can stay in that house or you can use that commercial property for your own business, or you can rent it out, license it out. Okay. And during the period when you have bought this property, you will have to pay a maintenance fees, house tax, commercial tax, whatever it is. Or if you have a car, you will have to pay a road tax and insurance and everything. So it's an ongoing process of maintenance. The patent process also works exactly the same way. Now if you are working on a formulation, if you're working on a chemistry patent or anything, okay, the first thing is not to go and buy the patent or not to file the patent. Basically, the first thing is to search the area, search the domain where you want to file a patent. So you go and file a patent in an area which is yeah, if you want, you can buy a property in Greater Kailash, okay, or South Ex, or you can go and buy a property in outskirts, and like you can go and buy a property near Jivar Airport. So it is an upcoming property, and tomorrow if the airport comes and if everything is good, that property will, prices will shoot up like anything. तो आप क्या करते हो, you will have to search for a domain which is either very popular, okay, which is currently trending, or you think that this particular invention, this particular thing will trend in the future. Okay. So if there is something which will trend in the future, you can look into it. You can do your inventions. You can plan your research activity around that domain, around that forte, and you can build a forte of patents over there. So there you don't need to have just one patent. You can make multiple patents in that area. Okay, so that tomorrow when someone comes into that region, you can say that, okay, see, I already have this patent with me. If you want to work in this area, you will have to pay me the licensing fees. Okay, so that is how exactly you do. And once you get a patent, you will have to pay the renewal fees for the 20 years. And this is one of the very interesting cases that I always tell, which really shows that there's no comparison to Indian brains. So if you are thinking that you are not good, only the Western people or the US people will do patents, let me tell you, Indian brains, there is no beating for the Indian patents brains. Okay, so there was a molecule called as cefaclor. Okay, and Eli Lilly came to India. They had way back in 1970s, there was thing which is called as process patent. India did not have a product patent at that time. So product patent will mean, agar ye pen hai, so if I know how if I have patented this pen, no one can make this pen by whatever method they want. Okay, but if I have a process patent, so I say that I will first make the body, then the cap, then the refill, and I will join them. So it is step A, B, C, and D. So if that is the steps, the process, the second process could be first I make the cap, then the body, then the refill, and the third one can first make the refill, then the body, then the cap. So all the three people can have three different patents in it. Okay. So India did not have product patent over there in 1970s. They had only process patent. We had only process patent. So when Eli Lilly came to India, they had patented cefaclor by 32 different processes so that nobody could invent any other process. So when they came to India in 1970, thinking that their molecule will be unique and patented by 32 protected by 32 patents, Indian scientists were so great, so smart that they could find out a 33rd method for making that particular molecule. Okay, and it was then at that time when vaccine got its recognition and everything. Yes, that their scientists are extremely brilliant. So why do you think innovations are important? That's the very first thing. If you just think like that, innovation is like any other thing, any other gimmick that is going on. Let me tell you, it is not like that. It's a very serious thing. And whatever research that you are doing, okay, whether you're doing an institutional research or you are doing a research in the industry, so most of the research is industry intensive industry, research intensive intensive industry. So when you talk of pharma industry, okay, so pharma, when you talk of either it is production, it's marketing, and a lot of it is research. Okay, so whether it be making a new formulation, lowering the cost of a molecule or a formulation, or making a formulation to dissolve fast, okay, or making a tablet which is less bitter, like taste masking and all. So pharma industry, when you talk of, it's a very research intensive industry, and any improvement that you do, see, it need not be an out of box altogether very new invention, very big invention. But even if you do an incremental innovation, that is also counted a lot, that also can be patented. Okay, and whenever you are doing any research, okay, there is a cost involved in terms of the time, the money, the resources, and everything. So currently, as a student or as a faculty, you might be thinking that we are spending, say, 6 months on a research project, or we are spending 1 year in a research project. But if you calculate everything in terms of industry and everything, it's a very high cost. So when you're investing your time and effort and everything, why not bring out something which can be patented and try to look at the bigger picture? And even if you're doing a basic research, so basic research could be like if you are just trying to enhance the solubility of a molecule, okay, so that not might be patentable, okay, or you are just studying to say the polymorphs of a molecule or something. Okay, so those things might not be patentable, but when you apply those basic knowledge into the applied field, okay, so you make a formulation out of it, or something out of it, so those things can be patented. Okay. And patents have got such a huge potential that if you are a startup, if you want to start your own company or something, and even if you have one single good patent with you, that is sufficient enough to establish your entire company for many years. Okay, so that is very important. So when we started our journey of intellectual property, so basically we had people in the wild. Okay, so the nomads were there, so they could invent the hammer, the wheel, and everything. And from here, the journey started. And then we had this industrial revolution where big factories, assembly lines, and everything was set up. And currently, as an individual, if you think so, if you don't have this huge amount of backup, or you don't have those connections who can fund you so much of money to make a big industry like this, the alternative that you have with you is intellectual property. Okay. So if you have a right patent at the right place, whether it is an enabling patent or a blocking patent. Okay, so enabling patent is something key, everyone is doing research, you also did a research, and you came up with an innovation or an invention which is going to help the industry. The other option is you can have a blocking patent. Okay. So the blocking patent is like, that 4G was there, 5G is there, now 6G is going to come, after some time 7G will also come. Okay, so all these things. So if you think in advance and you plan out something like, if you file a patent in say 6G technology, okay, or 7G technologies, or if you file something in terms of artificial intelligence, which is going to come in healthcare in a big way. Okay, so whenever there's another company who will try to walk on that particular path, they will find that your patent is there and they will not be able to use that particular thing. So in order to avoid being sued in the court of law or infringement, so it is better that they will come and buy your patent outrightly. Okay, so that is where you can use your intellectual rights or intellectual well-being, intellectual strength to gain money out of it. This was the situation in 2017, but it's not the same right now. And if you can just see the numbers, so globally, we just talk of the number of patents received. Okay, in the last column. So China filed around 1.38 million patents. US there were 6 lakh patents, and India had filed just 46,000 patents. And in terms of granting, when you talk, the 4 lakh patents were granted in China, 3 lakh patents were granted in US, and India only 12,000 patents were granted. Okay, and out of these 12,000, okay, so the number of 46,000 is also less. So number of filings are also less, and granting will obviously be less. Okay. So out of this, 7,112 patents were filed by people like you and me, or companies which are existing in India. Okay, and 10,000 above patents were filed by foreign people. Like there's someone, there's an inventor in US or Europe. He made his invention, he patented in US, and then he also wants to patent it in India. Okay, so that is how this number of 12,000 comes up. So the share of Indian people was very less earlier. Now we have risen above on the we're in the top 50 when it comes to global innovation index. Okay, and the share of pharmaceutical industry, the good news is that pharmaceutical industries contribute around 16% of this thing. We do a substantial amount of design filings also, but when it comes to trademarks, we do a lot of trademark filings. Okay, so trademarks kya hota hai basically? When you are opening your own industry or company or your startup or something, you will file for a trademark application. Okay, so higher number of trademark applications basically is an indicator of business acumen of the country. Okay, so there's a lot of businesses and people file for trademarks. Now, coming to when you talk of patents, there are 3 things that you have heard, you will hear from me also, and you have heard from everyone else. It is novelty, uniqueness, that is novelty, non-obviousness, and industrial applicability. Okay. So we'll take up each of the things one by one. And if you have any doubts, you can ask here also or in the middle also, and if you're fine, you can ask in the end also. So when you talk of novelty basically will mean that it is entirely new. Entirely new means, now suppose if you are making a formulation, okay, and you have five components. So you have one API 1, you have API 2, and then you have polymer 1, polymer 2, polymer 3, and then you have solvent 1, solvent 2, solvent 3. And if this combination is unique, like there is no one has reported this combination of APIs, polymers, and solvents, whatever it is, then your invention is unique. Okay. Now, this is not a very difficult thing to achieve. You have to do an exhaustive literature survey, see what are the components other people have used, and you will have to leave out those components and use some other uh, components into your formulation. Okay. The second thing is a more difficult thing and to achieve, which is called as non-obvious things. Okay. Now, suppose you have this combination where you have API 1 and 2, and then you have polymer 1, 2, and 3, and solvent 1, 2, and 3. So, अगर तीन polymer में से एक polymer suppose is a surfactant. Okay. Now they have told that they have used SLS as a surfactant. Now, what you have done in your formulation, you said that you were using, there was someone who has used SLS, and now instead of sodium lauryl sulfate, you are using some other polymer, say twins or spans or something else. Now, what happens, since there is someone who has already reported a surfactant, and you are also using a surfactant, so it is very obvious for a person who is skilled in the art, who has got knowledge of pharmacy or pharmaceutical sciences and research and chemistry and everything. It is very easy for a person to replace sodium lauryl sulfate with some other surfactant and make the same formulation. Okay. So it is very important that whatever you are doing, it should be non-obvious to a person skilled in the art. Okay. So that is very important. The third one is industrial applicability. Okay, and it is not a very difficult concept. So whatever you are making or using, it should be either be capable of being manufactured in the industry or being used in the industry. Okay, so if you're making a formulation, it can be used in the healthcare industry, and it can be manufactured in a pharmaceutical industry. Okay, so similarly, the only things which do not meet this applicability criteria are theorems and formulas. Now, suppose if you happen to devise a new formula for diffusion studies, okay, or you do make a method for compartmental analysis and pharmacokinetics, you develop a new model. So such things will not have applicability, and such things will not be patentable. So they will not have industrial applicability. So if you have any questions at this stage, you can just ask.
Amrish sir, I have a question.
Yeah.
Supposing we are making a mouth dissolving tablet,
Yes.
right? We have very obvious ingredients in that. I mean, there will be all the tableting ingredients will be there plus a super disintegrant, and that will constitute a mouth dissolving tablet.
Yeah.
So, how to make this unique and patentable?
See,
Because this is very obvious. I mean, but if we replace one of the ingredients, will it be considered for patenting or not?
yeah, if you replace one or two of the ingredients, it will become a novel combination. Okay. Plus, you will have to show what a technical advancement you achieved by replacing those all things. Okay. Now, suppose there is a person who has made a mouth dissolving tablet which dissolves in 10 seconds.
Okay.
Okay. And you make a mouth dissolving tablet which dissolves in 20 seconds.
Okay, sir.
Okay. So you have
There
not
is
done
no
anything
technical.
great.
Yeah, yeah.
So you have not done anything great. It was just a routine thing in which you have achieved something which is very normal.
Okay.
Okay. But if you can make a tablet which dissolves in 2 seconds,
Okay.
okay, then we can say that yes, it has got some goodness or some technical advancement in it.
Okay. With that same combination only or by some other permutation combination, if we can claim some better performance of the product, then we can claim a patent on it.
Yeah. So you should have at least a few technical advancements. You know? and the combination of ingredients that you are using, they should be unique. So for
Okay.
that, you need to do an exhaustive literature search and see the patents and the non-patent literature, whether that particular combinations that you are proposing, whether they have been used or not.
In case all those ingredients have been used, that combination already is there,
Yeah,
then still do we stand a chance that it is patentable?
no, very little.
Only on technical advancement? No?
No, no,
Okay.
because if the composition is already reported, making
Hmm.
the same thing, either you are making it in a different way, then it is then it is fine. But if you are
Okay.
using the same ingredients in the same way, it is very not likely that you will have a different result.
Okay. The method,
Hello.
you mean to say either the method has to be different, plus it has
Yeah,
to claim some technical advancement in product performance, then
yeah,
only we can claim a patent with the same composition as well.
yeah. So if the method is different and you are using some different ingredients, only then it will be patentable. If you are using the same ingredients,
Hmm.
the same temperature, the same rotation speed and everything is same, then it is obvious कि जो उसका result आया होगा वही result आपका आएगा.
सर तीन चीजें हैं, इंग्रेडिएंट्स, मेथड और तीसरा परफॉर्मेंस, है ना?
Yeah,
जो
yes,
प्रॉपर्टीज हुई एक तरह से
yeah.
प्रोडक्ट की,
हाँ.
है ना? तीनों में से कोई एक डिफरेंट होगा तो हम पेटेंट क्लेम कर सकते हैं, तीनों में ही डिफरेंस होना चाहिए तो हम पेटेंट क्लेम कर सकते हैं. आई मीन दैट्स
Either
वेरी
the
अ बिट कंफ्यूजिंग टू मी.
either the ingredient or the method.
Either of these, if it is
हाँ,
different we can claim.
हाँ,
With better
Okay.
performance, I think, है ना?
हाँ, with better performance obviously.
Yeah.
ओके
अगर
ओके.
आपका परफॉर्मेंस अच्छा नहीं है तो फिर आप क्यों पेटेंट करोगे? वो तो एक
हाँ बिल्कुल
नॉर्मल
बिल्कुल.
रिसर्च
वी हैव
पब्लिकेशन
टू
हो
सी
गया, पब्लिश कर दो.
इम्प्रोविजन इन परफॉर्मेंस
या,
एंड सम टेक्निकल नोवेल्टी इन टर्म्स ऑफ मेथड या इंग्रेडिएंट्स, है ना?
यस.
Okay, sir. Thank you so much.
So when you go for filing a patent, these are the various options that are available for you. So there's a provisional application. So in provisional application, basically what happens, you don't need to have the entire work ready with you. You have the basic methodology and the work that you're going to do ready with you. So you can, with that, you can file a provisional application. The provisional application, the good thing is that it will give you the priority date and it will give you a grace period of 1 year in which you can complete your work and file the complete specifications. Okay, so provisional application is something which can be filed based on idea or based on the methodology that you have developed. You don't need to have the results and everything with you. The second thing is called as a complete application. In technical terms, it is known as ordinary application because that is the usually what everyone goes for. So when you go for an ordinary application, you will have to have everything with you, your methodology, your results, your graphs, figures, whatever you have. And this application will also contain the claims of the invention. So claims of the invention will define the boundary of the invention, basically. And if you want to move out of India, there are two routes. One is convention application, where you file individually in different countries. The other is PCT international application, where you can go about, you get a grace period of 31 months from the date of filing if you go for PCT application. And after the 30 months, you can file in n number of countries. You will have to pay fees in all the countries, but you get a grace period of, or you get a time window of basically 30 months. Okay. And the national phase is for someone who's coming from foreign to India. Then you have two more things, patent of addition and division. Now, suppose if you are making this mouth dissolving tablet or something, and you did a research and you found that this formulation is absolutely fine, you filed a patent and you got it granted. But later on, other people also joined the invention, or you did further research on it, and you found that changing this particular ingredient into this particular thing, I can get even better results. Okay. So instead of filing a new patent, you can go for a patent of addition. Okay. And if ambitiously you claim a lot of things in the same patent, okay, then the government may ask you to divide the patent in two or more parts. So new, it means that it should not be published anywhere. It should be absolutely new and it should not be claimed in any of the patent specifications in India. Okay, so that is new. Inventive step, as I told you, it should involve technical advancement as compared to the existing knowledge, or it should have economic significance, or both. and the invention should be not obvious to a person skilled in the art. So when you were discussing about the points that you need to have this, either the ingredient should be different, or the method should be different, or there should be technical advancement. So even if you don't have a technical advancement, but you are able to have economic significance, that also stands a very good chance. Now, suppose if you have an analytical method which is using, say, acetonitrile, okay, at a very higher concentration. Okay. And if you are able to bring down the amount of acetonitrile that is being used, or you are able to replace that acetonitrile with water, okay. So in this case, you can have an economic significance, or you can, if you are replacing a very costly polymer with a very cheap polymer, okay, then in that case also you get this economic significance advantage, and this is a very strong point. Okay. So either technical advancement or economic significance, but whatever you do, it should be not obvious to a person skilled in the art. Okay. And then industrial application means it should be being capable or made or used in any of the industry. Okay. So apart from these three things that I have pointed out, that is novelty, inventiveness, and industrial applicability, there is another two sections in the Patent Act, which is section 3 and section 4, okay, which will tell you what all cannot be patented. Now, the art of thinking, what can be patented is yours. The government will not tell you what can be patented. The government just tells you what all cannot be patented. So if you make any machine which says that my machine will give 100% performance, it is contrary to the laws. There's always wear and tear and friction laws. Such things are absurd and will not be patentable. If you are using something which is not which is against the public order, like gambling machine, or if you want to make a biological warfare something, such things are against humanity and will not be patentable. Okay. Similarly, if you make some genetically modified organisms, such things will also not be patentable, except for microbes. Microbes are allowed because they help in other things. But if you want to make a genetically modified plant or an organism or an animal, such things will not be patentable. If you happen to be something like Newton or Galileo, something like that, and you discover some laws, such things will also not be patentable. Okay, so you might get a lot of accolade, even you can get a Nobel Prize, but when it comes to patent, you will not get, because these are laws and these are principles. So if laws and principles are patented, nobody will be able to use them. So the government does not allow you to patent such things. And another section, it says basically that if you are making salts or ethers or esters or polymorphs of a compound, so a compound is already known. What you did is you experimented extensively in the laboratory and you made salts. So it's a sulfate salt was known and you made a hydrochloride salt. Such things are very common in pharmaceutical sciences and nothing new about it. Okay, so such new forms will not be patentable, and even a new use will not be patentable. Okay. So if tomorrow you come up and say that I have aspirin, so aspirin is known for pain, it is known for fever, it is known for blood thinning. I have found that aspirin will also work for as an oncology in cancer also. So new use or a new property of a known substance will not be allowed, because there is a term which is called as evergreening, and none of the governments wants that people should take undue advantage of the system. So new use is not allowed in India. This is allowed in US, but not in India. Similarly, section 3E will say that if you are just mixing 2 or 3 things together, it will not have a patent. You cannot have a patent on it. Like neem tulsi, if you just mix together and you say that it has got some activity, it will not be patentable. Because that will be a mere admixture unless it is synergistic. So if you show that there's a technical advancement in it or there's something good in it, then it can be patented subject to other clauses, but otherwise it is not patentable. Similarly, if you just arrange 2 or 3 things together, like you put a bucket with a torch or an umbrella with a fan, so the umbrella and the fan don't really integrate. There's no use of a fan and the umbrella, or like there's no integration of the things. Okay, so such things will not be patentable. However, if you put a camera into a mobile phone, Now there is a lot of integration and everything. So that is patentable, but simply combining two things is not patentable. The method of agriculture or horticulture is not patentable. Okay, but if you are making a composition for fertilizer, or you are making say a plow or a device which is going to be used in agriculture, such things are patentable, but the method of agriculture is not patentable. Similarly, when it comes to medical sciences, the method for removal of cancer or surgical process or blood transfer, things are not patentable. Okay, but if you make a composition for a particular thing, okay, or you make a kit for something, so such things will be patentable. But as such, the procedures will not be patentable. If you, in terms of plants and animals, section 3J says that plants or animals in whole or part thereof, uh, other than microorganisms, but including seeds, cannot be patented. Okay, so like if you're making a clone or something, cloning or anything, so such things will not be patented. Similarly, mathematical methods, business methods, algorithms, computer programs, such things will not be patentable. Okay. But again, if you are using a computer program which is connected to a hardware, to a cloud computing system, to a CPU or a server or something, and it has got some sensors like temperature sensors and other things, then it becomes a system, and the system is patentable. But if there's someone who just wants to protect the program, computer program, they can go for a copyright, but they will not be able to go for a patent. But taking the system as a whole, it is patentable. The computer programs along with the system can be patented. Similarly, a song, poem, drawing, sculpture, these things cannot be patented. They are covered under copyright. Method for solving rubrics and other things, again, these are mental act and they are not patentable. Things like information or presentation of information is not patentable. So if you make a very fancy diagram or something, such things will not be patentable. You can go for copyright or other things, but not patents. If you happen to make a new circuit layout, that again will not be patentable. Okay, and section 3C or 3P also says that if there is something which is already reported in the public, in the traditional knowledge, so if neem is already known as antibacterial, okay, you will not be able to patent neem as a formulation component in any of the thing which shows activity as antibacterial. Okay, so it is very important that when you're working with herbals, we need to check what are the domains in which it is already reported. And section 4 says that things which are related to defense technology or atomic energy like uranium, beryllium, such things, if you're working on it, such things will not be patentable. Okay. And when it comes to patents, there are two kind of things. One is conditional exceptions, and there are absolute exceptions. Okay. So when you talk of, say, a new form of a known substance, okay, or the mere use of a known process, or a mere admixture, okay, so such things are called as conditional exceptions. So the government of India says that section 3D and 3E, they cannot be patented. Okay, so new use or a new form cannot be patented. Okay, but then there are ways by which you can circumvent these particular sections, and you can show that your formulation does not fall under these categories. So these are called as conditional exceptions. So they can be overcome by proper drafting and other things. But there are other things which are called as absolute exceptions. Okay, so if you are claiming a new use of a particular thing, or you are claiming a method of treatment, okay, such things will not be patentable even if you do the best of the drafting that you want to do, or you hire the best of the attorneys available over there. So if you want to claim a new use of a compound or a method of treatment, these two things you cannot overcome by the best of the drafting also. But again, so the method of treatment is not patentable, but the composition or the device is patentable. Okay, so just be clear with it. So When you take it as a whole, you can just say that a patented claim has got 4 components, say A, B, and C, and D. And there was a smart guy who reduced one of the components from this. Okay, so आपने एक पेटेंट एप्लीकेशन पढ़ा और उसमें देखा कि 4 चीजें हैं और आपने एक नई फॉर्मुलेशन बताई बना दी इसको, इसमें ए बी और सी था और डी आपने हटा दिया इसमें से। ओके, अब क्या आपको पेटेंट मिलना चाहिए कि नहीं मिलना चाहिए? आपको पेटेंट मिलेगा। क्यों मिलेगा? क्योंकि इसमें 4 कंपोनेंट्स थे, आपने एक कंपोनेंट हटा दिया, कंपोनेंट हटाने के बाद भी आपका रिजल्ट सेम था, ठीक है, और आपने डी कंपोनेंट हटाने की वजह से कॉस्ट इफेक्टिव बना दिया, ठीक है, तो डी की जो इकोनॉमिक सिग्निफिकेंस थी वो इसमें आ गई। एंड सिंस द एक्टिविटी एंड एवरीथिंग वाज सेम, ओके, यू कैन गेट अ पेटेंट ऑन द प्रोडक्ट by removing one of the components from the patent formulation. So if you just go through internet, see the patents, find the compositions, remove one of the components, and you can have your own patent. On the other hand, if the patented claim has got 4 compounds, A, B, and C, and D, and you try and add one more compound to it, okay, then in that case you will not be able to get a patent, because what happening is you are already reporting all the components of this patent. Okay, so all the components A, B, and C, and D are found in your product, plus you have an additional component which does not which makes it obvious key, because he has already reported the 4 components, you are using the 4 components as reported by the person, so your invention will not have the will not get the patent. So there are other sections which is called as 21J, which says that the invention that involves technical advancement as compared to the existing knowledge or have economic significance or both, and makes the invention not obvious to a person skilled in the art. Okay, so this is what section 21J says. Section 21J says involving an inventive step and capable of industrial application. 3D deals with new form, new use, or a known process. 3E is about admixture, and 3I is for treatment. So if you have to justify the clause 21J, you will have to justify that the prior art is lacking, or it is not known, or the prior art is guiding you away from carrying out your invention. So these are the justifications that you can give to justify your section 21J clause. For section 3D, you can elaborate on 3E, saying that it is not a mere admixture, but it is synergistic combination. And for 3E and 3I, you will have to divert the invention, saying that the prior art is lacking in all the information, so you won't fall under the gambit of 3E and 3I. And for 3I, you will have to reword the claim. So if you have said that a composition used for treating Alzheimer, okay, so instead of using the treatment word, you have to say a composition capable of reducing, say, insulin level, or controlling the brain neural response, or enhancing the memory. And you will have to avoid the word treatment over there. So pharmaceutical patents, when you see, if you have this structure, like say it's a pentagon, okay, and so so if you see, say you were the first one to invent pentagon, okay, this pentane, okay, and the patent agent or the patent examiner says that I have seen this particular mark on the T-shirt of a Superman. Okay, so will it be patentable? You have worked tirelessly for years in the lab and made the first molecule like this, and the comics which your child reads, you find that this kind of a design is also there on the shirt of the Superman. Okay. So basically, yes, your thing will be patentable, because when the Superman wears this particular symbol, it does not tell you how to synthesize this particular molecule. Okay, so that is what you have told. So you will be able to get a patent on that. Now there was a molecule called as clorazepine, okay, and clorazepine is one of the first compounds with a therapeutic effect on schizophrenia. However, just like many other first generation antipsychotics, it resulted in unpleasant side effects. So it had a lot of side effects. So the government worked, so the people worked on it, and for chlordiazepine, they made something called as clozapine. So they removed this molecule over here, and they made something like this. So when clozapine came in 1959 into the market, showing the same therapeutic effect and less side effects. Okay. However, in some patients, it led to a fatal suppression of WBC. Okay. So whosoever was taking this particular molecule, clozapine, he had to go for a regular weekly blood test. So to just see whether what is the condition of the WBC. Okay. So this is the difference. So, taking the basis of chlordiazepine, another molecule was developed, which was called as olanzapine. Okay. Now, when olanzapine came into the market, it was a product of Eli Lilly. Okay, and it was a commercial success, seventh biggest selling molecule of 2006. Okay, and so what happened? People were very like. It was so successful that the competing companies tried to sue it for the lack of novelty. Okay, so everybody wants, they don't want their competitor to succeed, so they just wanted to destroy this molecule. So they filed, they said that this structure is very much similar to chlordiazepine structure, and this should not be patented. Okay. So on the first instance, the court nullified olanzapine's patent as the deemed patent to lack novelty, and that the old patent from LLD was a prior art. But in 2009, the court justice reversed the initial decision and reinstated the patent. So initially, the court rejected this patent and stopped this molecule from being marketed. But later on, they said that this olanzapine is a new molecule. Okay. So now what happened basically, what the competitors did was they said that this particular molecule is known, and here you have R1 and R2, okay, and here you have, you can say R3 or whatever it is, and this is T, which can be changed. Okay. So if you change R1, R2, you also change this Q, and you also change this moiety at T, or this whole moiety. What is the possibility is that you can make 10 to the power 19 chemicals out of it. So for R1, you can put chlorine, for R2, you can put bromine, and then you can just make this combinations and everything. So the possibility of making the number of chemicals is 10 to the power 19 moieties can be made by replacing this R1, R2, Q, and T. Now it is impossible for anyone to make so many molecules and do all the research and find out which molecule is active or which molecule is inactive. So olanzapine was never disclosed and had no prior art. So this is the structure of olanzapine. So you can just see the difference. So here you have this fluorine molecule, and here there's no fluorine molecule over here. Okay. So in this particular example, when you see this R1 over here, so R1 was reported as chlorine, fluorine, bromine, and everything, but it was not reported that R1 will be null. Okay. So that was not reported anywhere in the literature. And this is how the molecules came. So you can see fluoxetine, it had a fluorine molecule. Fluoxetine had a chlorine over here. Okay. And olanzapine did not have anything over it. Okay. So just because these things were not reported in the earlier patents, okay, anywhere, so olanzapine could hold the patent on its own. And moving forward, when it comes to patent drafting, okay, it is more like a research article that we draft, okay, with a little bit of legal consideration and a lot of technical consideration. So when you have this patent filing, basically, you have a few common things, a lot of common things, basically, with the research article that you must be writing. So you need to provide a bibliographic information. So you provide the details of the inventors, the proprietors or the owners, and the date of filing, the technology, the class. Okay, so this is the bibliographic information which should be there. Okay. Then you need to have a draft of an abstract. So there's a limit. The abstract cannot be more than 150 words. Okay. So normally we would like make an abstract of 200 words or 300 words, but patents across the globe, 150 word is the limit. You cannot have more than 150 words in the abstract. And this abstract should be very much relevant to the work that you have done. Okay, so they should describe the problem that you have solved and how you have solved that problem. Okay. So following abstract, there is the rest of the document is basically a description part. Okay, so the description will have summary of the prior art. That is, it will have the technology most similar to the invention. Okay, so there will be a section on prior art. Okay, that is also called as the background of the invention, and you will tell that see, I made this particular formulation, and earlier people had made this but they had failed. This is there but it does not have this advantage. They have this but it tastes very bitter, and now I have made this particular formulation which is got which is overcoming the previous problems reported in the previous prior art. Here in the background you don't need to give more details about what your invention is, because you have further sections where you can put that. Okay, so in background, you just need to put what the problem was existing and how you have solved that problem. The problem that the invention is supposed to solve, that has to be mentioned, and the detailed explanation, and at least one way of carrying out the invention, that is the experimental section or the examples. So you have to give further in the description, you will give the advantages of your invention. What are the technical advancements? What is the invention? Okay, what are the technical advancements and the advantages you will have to mention. Apart from that, you will have to give examples. Okay, now suppose if you are saying that you have made a transdermal formulation or a mouth dissolving formulation, or you have made a new chemical moiety, or you have made a herbal formulation or a method of analysis, by way of examples, you will have to give how you have done that particular thing. Okay, so in routine work, we would call it as an experiment. But when you write a patent, that experiment has to be written in the form of an example. Okay. This is followed by the claims. Okay. So claims are something which define the extent of patent protection. Okay. So you must have made, say, a transdermal formulation, a tablet, or a mole dissolving formulation, whatever it is. Okay. But if you just write one single sentence that you want to claim is, if you want to claim a mouth, I claim a mouth dissolving tablet. Okay. Now, if you just write a mouth dissolving tablet, and that is what you want to claim, this is going to be a very, very broad claim. And if you get a grant on this particular claim, no one else in the entire world will be able to make a mouth dissolving tablet without your consent. Okay, or without paying you a royalty. So, but that is a very outdated thing that will not be possible because there's a lot of literature already reported on it. Okay, so what you have to do is you have to narrow down your claim. Okay, and how do you narrow down? You will say that I have a mouth dissolving tablet. It will have API 1, API 2, polymer 1, 2, 3, solvent 1, 2, 3. The ratio of these things will be so and so and so. Okay, so that is how you're going to narrow down your claim. Now, what happens? You will get a claim on a mouth dissolving tablet which has got these 7-8 ingredients in it. Then there will be a section on drawings, which will have the whatever say figures or diagrams that you're claiming. So those things you have to add. And these are not called as figures; they are basically called as drawings in patent terms. In the detailed description, there should be at least one way of carrying out the invention must be given. Okay, and the description must disclose the features essential for carrying out the invention in sufficient detail. Now, if you want, if you if you are very secretive and you say, why should I disclose all the information, my patent and everything? It is fine. You can still draft the patent and file it. But when it goes for a grant, basically, you will have to face a lot of struggle because you have not described your invention in sufficient detail. So basically, the objective of patent filing is that you disclose the invention to the world, and in return, the government gives you a 20 years of monopoly right on that particular invention from the date of filing. Okay. So you should put in sufficient amount of detail over there. Okay. A single example is okay, but if you want to patent the various differences, now suppose if you say that the polymer ratio is 10%, it is fine. You can just claim 10% polymer ratio. But if you want to claim a polymer ratio of say 10 to 50% or 10 to 20%, then you might be required to give three examples: one at 10%, one at 15%, and one at 20%. Okay. So that is how the things will work. So if you want to have a larger range, okay, then you will have to give more examples, and it will be a more extensive patent. It will be a bigger patent. Okay, there will be no more number of pages, and the claims will also become big. Okay, so now if you're claiming a composition with 10% and you're claiming a composition with 10 to 20%, then obviously the some other person who is using say 15% or 11% or 20% or anything in the range 10 to 20% will not be able to make that invention. The whole idea claimed is to be understood as substantially and involvement failing within the ambit of a claim. So whatever you are claiming, whatever wordings you are putting in the claim, that is what you get the patent on, and you don't get the patent on whole of the thing that you have described. Okay, you get the patent on only the things that you have claimed. And how do you reach upon the claims? You reach upon the claims when you do a very, very exhaustive patent searching in order to see what others have done and where is the gap where I can pitch in. Okay. And if you are using any microbes in your research, if you're working on some fermentation product or biotech product or something like that, then these microbes have to be deposited in the microbial culture collection, okay, as per Budapest Treaty of 28th April 1977. In India, the center is MTCC at Chandigarh, where you will have to deposit the microbial strain on which you are working. This does not hold true for if you are using a micro for evaluating antibacterial activity, suppose. Okay, then you don't need to do it. But if you are you isolated an organism from the soil and then you cultured it and you derived some product out of it, okay, then in such a case you will have to deposit this microorganism. And similarly, if you're using any plant, okay, like you're using herbals or plants or anything, then you need to take the permission from the National Biological Authority, okay, under Biological Diversity Act. So this is an additional step when you are using herbals or plant in your formulation. So when you have claims, claims are two types. There are either product claim or a process claim. Okay. So product claim is the chemical compound or a mixture of compounds. And apparatus could be a physical entity like you're making a machine or something like that. Okay. So a physical entity could be object, article, apparatus, machine, okay, or such things. Okay. And then there is another thing which is called as a process patent. And this process patent is applicable to all kind of activities exercised upon the material products, upon energy or other processes, as in control process or upon living things. So if you are like you have a method of synthesis, method of analysis, okay, so all these things are covered under processes. The use of substance X as an insecticide is equivalent to a process of killing insect. Okay, so instead of using the word, you can say a process of killing insects. So such things are patentable. So you have product and process claim. These are two major things. And when you draft basically a claim, so it will have one or more independent features, and then it will have dependent features. Okay. So if you say that you have say I claim a mouth dissolving tablet, okay, and then you say that the mouth dissolving tablet contains API 1, API 2, API 3, and then you say that it further contains polymer 1, polymer 2, polymer 3. So this is how it is. So if you say that a mouth dissolving tablet, that is the independent claim, then you say that the mouth dissolving tablet comprises of API, polymers, and solvent. And then you say that the API is 4 and 5, and then you say further go down and you say that the polymer is 6 and 7, and then you say the solvent is XXX. Okay, so this is how you basically make the claims. Okay. So making it more clear, so you have say a mouth dissolving tablet, and then you say that you have this 10 to 12 or 13 polymers in it, poly ingredients in it. Okay, wherein this particular five, say a surfactant can comprise of sodium salts, and where it can comprise this and this. So this is the main claim, and this can be the smaller claim. And then you can have a different claim, like say claim 17, which will just say that the method of making this small dissolving tablet or something is step comprising of step 1, 2, 3, 4, and so on. So you can have independent claims and you can have dependent claims. Okay. Then there are two important words that you use when you draft your claim, that is comprising and consisting. Okay, so almost 99% of the time we go with the word comprising. Okay, and it has got a broader meaning. So it says including, containing, or comprehending, you know, and not excluding the presence of any additional component. So when you say comprising, it means that ये तो है ही, इसके अलावा भी कुछ भी हो सकता है, ठीक है? But when you say consisting of, okay, it means that it will have only these components A, B, and C, and nothing else other than this. Okay, so that is where the difference is in comprising and consisting, and this is very important when you are drafting claims and other things, because these are very small. So you will get a grant when you write comprising also, you will get a grant when you write consisting also, but the scope of the claims will vary. Okay. And then you have to prepare for the experimental part. So you will have to mention all the essential features of carrying out the invention in sufficient detail, which is very must. Okay, so if you try to skip out the procedures or the methodology at this stage, later on it becomes very difficult to add on the things to the patent. Okay, so a patent and a review or a research article is different, because in research article you may be able to add something later on, but in patents it's very difficult to add anything later on. Okay, so it's always best to give as much information as you can. Even if you put some extra features in it, it does not make difference. You never know when they come handy to use. Okay, and then highlight the distinguishing and essential features that you have to do. Okay, so whenever you are sharing your work with a patent agent or anyone for drafting other things, so this is these are very essential things, that you give a full disclosure. You distinguish the essential or the structural features of invention. You tell that my invention is unique because of these particular things. My invention has got these particular advantages as compared to the other products which are already existing in the market. Okay, and try to generalize your experiment. So you have to think on a broader perspective. Okay, if you are saying that I'm using, say, one of the surfactants, say sodium SLS. Okay, so you have to tell that the patent agent that though I'm using sodium lauryl sulfate, but there are people who can use other surfactant also. Okay, so when you are designing these claims and everything, so that all could be taken into consideration. Then you have to prepare a brief description of the state of art, what is already existing and what all needs to be put in. And then once you have all this thing ready, you can leave out the claim drafting to the patent attorney, or you can use the words like comprising things, and you can draft your claims. So these are the various stages of patent filing. You file a provisional application, you have 12 months of period, then you complete your application, and then it gets published. And you have a 48-month window to file a request for examination from day one. Okay, so unless you file this request for examination, your patent will not be examined. You will not receive the FER report, and it will not go for a decision. Okay, so that this is a mandatory thing, that is request for examination. So once you file a patent, if you are filing online, a lot of formality checks will be done online. And if you are submitting a manual paper, then it will be done at the counter when you are depositing the form. And once you have submitted your patent application, it will be published within 18 months. You won't have to pay anything extra. But if you want to get it published before that, within a month, say, then you will have to file for a early request. Okay. So once you file it, this is how you get the document. You have the official journal, the date, the volume, and it's published on every Friday. And it will contain the name of the application, the details, the abstract, number of pages, number of claims, and everything. After this, you will have to file a request for examination. The time period is 48 months. You can file it along with filing also on day one, or you can file it in 4 years. So once the examination is filed, it will go to the examiner, okay, and they will evaluate your patent. And if you want, you can file for an expedited examination. So usually patent application will be examined in say 1 year or 6 months or more. Okay, but if you file for an expedited examination, the examination report comes usually in 6 months or less. Okay, so once that is done, an FER, or that is called as first examination report, is issued, and this is how the FER will actually look like. Okay. It will have a lot of documents and everything, and then you have to reply to this FER, and the time period is 6 months. Okay. So within 6 months, you need to reply to this FER. So you will have to draft a properly written letter saying that this is what it is, and you will have to reply to it. So once you reply to it and everything is fine, you can expect a grant of the patent or a rejection of it. If there is a rejection or a likely possibility of a rejection, the patent office might call you for a hearing. It's called a hearing in technical terms. In layman language, you can call it as a video conferencing interview, where you will have to explain your patent. Why is it novel and inventive? And once it's done, it's granted across. So this was one of the patents that we filed for a faculty member, and it was granted in less than a year. So in 363 days exactly, it was granted from filing to grant. It was 363 days. And as such, if you talk, a patent agent is not required for filing a patent. You can file it on your own. Okay. But it's since the document is a technical and a legal document, it's always advised that you go with someone who is expert in the area. So these are the various forms and fees which is there. Okay, so you can go for a patent grant. Form 1, the fees is there. Form 2 has got no fees. Form 3, 5 have no fees. Form 9, that is early publication. If you want to go for, this is 2,500 additional. Form 18 again has got a fees. Again, it can be paid within along with the application or later on. So the fees is 4,000. If you go for expedited examination, the fees is 8,000. And if you take the services of patent agent, there's no fees for the form that you need to fill. And this fees, the fees of 1,600 is for 10 claims and 29 pages of your application. So if you exceed the number of claims, then you have to pay 320 rupees per claim. If you exceed the number of pages, you have to pay 160 rupees per page extra. So patent rights, just taking through a brief recap kind of a thing. Patent gives you the right to make and sell a product or a process. The answer is no, basically, because the patentee, you get the right, it's a negative right basically. So what basically happens is that you get the right to stop others from making and selling the invention. You don't get a right to make the invention. The patent term is for 20 years from the date of grant. The answer is that yes, it is 20 years, but not from the date of grant, from the date of filing. तो जिस दिन से आप पेटेंट फाइल करते हैं उस दिन से आपके 20 साल की घड़ी चालू हो जाती है. A patent does not give you a worldwide right. It has to be a territorial thing. हर कंट्री में आपने अपना पेटेंट फाइल करना होता है अलग-अलग, ठीक है. And the patent should be made when the product is ready. Mostly yes, but at times no. You can file a provisional application also. Okay. So you don't always need to have the product ready with you. You can file a provisional and then you can make the complete application within a year. Publication can be made after publication of the work. The answer is a bit dicey, yes or no. Okay. Most of the time, the patent office will not entertain this thing, but the law says that you have a grace period of 12 months, and this grace period basically kicks in only when your work has been published without your consent. Okay, so if you are publishing your own work in a journal where you are signing the copyright and giving the publisher the right to file your own your research work, then this clause does not work. But if your work has been published without your consent, okay, like suppose you deposited your PhD thesis to your university, and the university uploaded it on Shodh Ganga portal, and it got published online. Okay, so there was no consent of yours. You did not sign any document. You did not give any permission. So in some cases where your permission has not been awarded, in that case, and every invention is patentable. कुछ भी बनाओगे पेटेंट हो जाएगा क्या? नहीं, क्योंकि there are section 3 and section 4 which tell you what all cannot be patented. Okay, so with this, I just thank you for your presence, your patient listening, and we are open to questions.
Thank you so much, sir. Very enlightening session. But always patents का जो भी session होता है उसमें इतनी सारी queries सबके दिमाग में आती हैं. I think there were a few things in chat box. Participants, if you have any questions, please put them in the chat box. Meanwhile, I'll request Dr. Vandana. She is our group director, Lloyd, and she is also the president of IIC Institute Innovation Council. So I'll request Madam to just say a few words.
Thank you.
Hello, good evening.
Hi, Dr. Amrish Chandra. How are you?
Fine, ma'am. How nice
Very
meeting you.
insightful session, sir. It was very enlightening. I attended parts and bits in between. And when it comes to IPR, I have really not seen a better speaker from pharmacy fraternity who has so much clarity on the subject. And you're very thorough with it. So my compliments for a good session. I'm sure it makes sense to a lot of faculty and a lot of industry personnel who are present on this forum. हो सकता है बच्चों को थोड़ा सा कम अभी समझ आया हो. पेटेंट्स एंड आईपीआर हम लोग के बीफार्म के सेशन में इतना जोर नहीं दिया जाता इनको. Some master students are also here, so I'm sure they would have understood at least some introduction about what happens in IPR. Also, in this series of the impact series that we are doing, it's immense participation that Lloyd has received. A lot of institutes, around 28 organizations, and around in fact around 96 organizations and 28 industry personals are going to be participating in this impact series lectures. And this is a very good initiative of AICTE when the students are getting exposure of a lot of things beyond their study material, and that too in areas of IPR, in areas of entrepreneurship, which actually is going to help you. This is the crux, eventually आप लोगों का career इन्हीं fields में बनना है. What you read in your books is a good base to your career, but it is not a career. So अगर आपको कुछ skill related करना है, some skills that you need for your professions, and you have to attend to these kind of lectures to have to understand more. So I think lecture is just an introduction, but we will have more workshops on this, and we will request Dr. Chandra, also maybe later on sometime when it is suitable for you to take maybe 1 or 2 days workshop on, these factors, very basic to the final filing of the patent. I understand not everybody can clear the patent exam and go become a patent agent. But yeah, they can at least understand on how to write their, patents themselves.
Yeah.
Also, my compliments to Dr. Chitra and Dr. Lalit and Dr. Kumud, who's taking up, this initiative for Lloyd. It's a wonderful initiative, and I hope to listen to good speakers also on this. A very good meeting has been made with Dr. Amrish today on our platforms. Thank you very much, sir, for coming in.
Thank you very much.
We'll be open to taking questions from students.
Yeah, sure.
Dr. Chitra, you can take it up.
Yeah, thank
and
you,
I
ma'am.
always compliment Lloyd for taking such initiatives. We see Lloyd taking a very, very enthusiastic approach. If we happen to see this, and it's one of the premier institutions which is doing A lot of things in IPR, bolo, या फिर you talk of placement melas and other things. So my heartiest compliments to you for leading such an organization.
Thank you.
Thank you, Amrish sir, and thank you, Vanda ma'am. We have someone amongst the participants raised hands. Tapan Moto. Can we unmute him, Preeti? Tapan sir, would you like to take up your question?
Sure, ma'am.
Or Chitra ma'am, for simplicity, you can ask questions from the chat box.
Chat box, ma'am. I don't think.
Sir, good morning, sir. Hello.
Yeah, good morning, sir.
Hello. Madam,
Yes,
good
sir.
morning. Am I
You're
audible,
audible,
sir?
sir.
Yes, sir. You are very much audible.
Sir, I want to ask two things that claim. Okay, thank you, ma'am. Actually, sir, good morning. And
Tapan sir, your voice is breaking.
Two things. First
Tapan
one
sir.
is the claim is the one of the most important
Preeti, can you
part of the getting the patent.
question in the chat box?
So my first question is there? Okay,
Tapan sir,
okay, madam.
it would be better if you put your
Now,
question in the
madam,
chat
now
box.
my hello.
Tapan sir, please put your question in the chat box. Your voice is not clear. It is
Yes,
breaking.
madam.
Your
Okay,
connection is
madam.
not stable, probably.
Okay.
Please put your question in the chat box.
Okay, madam. Right. I am writing my question in the chat box.
Anyone else, meanwhile, please put your questions in the chat box if you have any queries.
I am writing in the chat.
सर एक क्वेश्चन अमरीत सर मुझे चैट बॉक्स में दिख रहा है फ्रॉम नेहा शी इज सेइंग व्हाट इज द
Okay.
डिफरेंस बिटवीन पेटेंट ग्रांटेड और पेटेंट रिसीव्ड आई थिंक प्रोबेबली शी wants to know the difference between patent granted and patent filed probably.
Yeah, yeah. So the process is like you enroll for a degree and then you get the degree awarded. तो लाइक एडमिशन कोई भी ले सकता है, ठीक है, बट जो सारे एग्जाम्स को पास करता है दे गेट द डिग्री. So similarly for patent filing, so you can you have your work, you can file for a patent, but once it gets to examination, FER response, and if there is a hearing, then through hearing, and then finally when the government of India approves that yes, your invention is novel, inventive, and it has got industrial applicability, it does not fall under section 3 and 4, it is then that you get the grant of the patent done.
There is another question, Dr. Ritesh Kumar. What is the estimated cost and time for patent publication?
So the patent publication usually happens if you go for early publication. I told you the fees is form 1 you need to file, form 9 you have to file. So the cost is 1,600 and 2,500, and it takes around a month after the date of filing for you to get the patent published.
Sir, Tapan sir's question is there. Is there any rule to file minimum or maximum number of claims?
No, there is no rule. It all depends on how big or how small you want to make your boundary. But
So,
the fees that you pay is for 10 claims. If you increase the number of claims for beyond 10, for every additional claim, you have to pay 320 rupees.
so Tapan sir, I hope you got your answer.
There are inventions with the 100 claims also, or more than that also.
Pragati, you want to ask something? Pragati Belwal. Uh, I think, sir, that should do for us.
Okay, fine.
Thank you so much, Amrish sir, for joining us at such a short notice. And I would like to present an e-certificate to you, which will be later on mailed to you.
Okay, fine.
Thank you so much, sir.
Thank you. Thank you very much.
Thank you. Thank you. So, participants, it's time to welcome our second speaker. We have Dr. Rajiv Kapoor. Sir, are you there? Dr. Rajiv Kumar Kapoor.
Yeah, Chitra, I'm here. Sorry, I didn't unmute myself. I'm here.
Okay, sir. Welcome,
Please carry
sir.
on.
Please accept this bouquet.
Thank you.
So, sir, I'll request you to go ahead with your talk once I give your introduction to the participants.
Sure.
So, Dr. Rajiv Kumar Kapoor is a qualified patent agent for the Indian Patent Office, IPO, and has been shortlisted as patent facilitator for Startup India 2016 initiative of Prime Minister Shri Narendra Modi. Dr. Rajiv has done his postdoctoral research from University of Arkansas, USA, and his doctorate in microbiology from Delhi University, and done his master's in biotechnology from MDU Rohtak. He has more than 28 research papers to his credit and 5 book chapters with more than 1,000 citations, an H index of 18. Sir has supervised 1 PhD and 40 PG students and has been principal investigator in several sponsored research projects. He has received several awards and honors. So let's welcome Dr. Rajiv Kapoor. Over to you, Rajiv sir.
Yeah, thank you, Chitra, and wishes to all of you. And I think you've organized a wonderful series, which makes a lot of sense for the students of pharmacy, because what I feel is that pharmaceutical sciences can contribute a lot, not only to the society but to the country also, because by way of patenting and by way of commercializing drugs, they can generate a lot of revenue for the country also. So there are many examples of drugs which have turned the future of a company, of a country, of the inventors. So organizing such seminars where patents are discussed or IPR is discussed makes a lot of sense for the students of pharmacy. So I was listening to Dr. Amrish also. He very comprehensively described the complete process, and I should say that he is very thorough. Previously, I used to think that I'm amongst the only professor who is also an patent agent, but I met another person today. Amrish is also there, who is also a patent attorney and is a national facilitator for the startups also. So good to meet you, Dr. Amrish. I also hold a similar profile in the university. And apart from my teaching normal curriculum in the field of microbiology, I also look after the patent filing process of the entire university. So I play an important role in helping them draft their applications and in the filing process. So today, the topic of my talk would revolve around patents, because amongst the different IP rights that exist, like you have been listening to, like copyrights, trademarks, trade secrets, geographical indications, chipset designs, farmers' rights. So for you guys, you coming from the pharmacy background, the most important aspect would be, or the most important IPR would be patents. So my talk would be more focusing on patents, how patents are drafted, what are patents, and especially I'll be elaborating section 3D, which tells us specifically that what is not patentable. I'll be telling about certain procedures or certain precautions which has to be taken care of while drafting the complete specifications. I'll be telling you about the structure of a patent, how a patent is written, and how to make sure that uh, you you are completely enabling your patent, because this is a prerequisite for every patent document that should be completely enabled. We will talk about that. Then I'll talk about claims. Then examination, how the examination takes place, about how to defend your patent. And two topics I've also included. One is the PCT application, which I feel that everybody should know that this is another kind of a patent application which can take you to any country or the signatory countries of the world. So you can practice, you can implement your invention in any part of the country, the world. Lastly, I'll be also including Budapest Treaty, that is specifically for microorganisms. So, like I'm a microbiologist, and we do keep working with microorganisms, and there are many microorganisms which produce metabolites which are of medicinal importance, which are of industrial importance. So, how to hold a patent where you are using a microorganism? Because microorganism is a naturally occurring organism, and naturally occurring organisms are not patentable. So how to obtain a patent over a microorganism? So there is a treaty which is called Budapest Treaty. So if you're using a microorganism for which is a part of your invention, or using a metabolite derived from a microorganism, then this treaty comes into play. I'll be speaking about that. So let me begin with the basic definition. As I told you that we'll be focusing only on patents. We won't touch any other kind of a copyright or any kind of a IPR. So it's a limited monopoly right. Why I'm saying limited? Because it is only for 20 years, which is conferred by the state in consideration of disclosure of the invention. It is just like तुम मुझे खून दो मैं तुम्हें आजादी दूंगा. That was a famous saying of Subhash Chandra. He said that if you disclose, the government says, if you disclose your invention completely, and so that it can be practiced by any person, if you completely disclose the art to me, and in return the government will give you a right, a monopoly right, so that you are the only person who can sell, who can license, who can export, who can derive any sort of commercial benefit out of that patent document. So if you're disclosing your work of several years, because to generate a patent, it needs a lot of work, a lot of money also. And that whole effort, it is an effort of what could be a team or could be an individual of many years. So if you're disclosing all that to the public, so in return, you can get a right, which is called a patent. And this is a monopoly right, and this is given for 20 years. So that's what a patent is. So we'll talk about the Indian law and system. So you can see we are the Indian Patent Office has 4 jurisdictions: Kolkata, Mumbai, Chennai, Delhi, and all the states are classified, and they are into any one of these jurisdictions. For example, we will be filing Himachal Pradesh, Haryana, Punjab, Jammu Kashmir. They all will be filing to Delhi Patent Office. And similarly, the joining states to Chennai, Mumbai, and Kolkata, they will be filing their respective patents into the respective jurisdictions. And this is, yeah.
सॉरी टू इंटरप्ट सर, आप अपनी स्क्रीन को मैक्सिमाइज कर लेंगे पीपीटीज?
Here it is maximized at my end. Let me check again.
In our view,
Is it because what I see is maximized?
No, sir.
Is it still the same problem? You cannot
Yes,
see.
sir. सर एक बार स्टॉप शेयरिंग करके दोबारा से
Okay.
शेयर करेंगे तो probably you'll get this.
Okay.
No, sir, still the same problem. It's in PPT.
Now,
No, no, sir, no. Preeti ma'am, any ways we can help out, sir, with this?
हम रीशेयर करें सर एक बार.
that I did, and I'm doing it again. I'm
हाँ. Stop sharing.
And now I have clicked.
So please click on screen option.
I got a screen option. So that is
Press F5. Yes, sir.
It's okay now, sir. Fine, fine, fine.
all right. So I was talking about the jurisdictions. Yeah, I think Amrish might also have told you about the jurisdictions. So we, the entire India falls into 4 jurisdictions, that is Kolkata, Mumbai, Chennai, and Delhi. And we are part of the Delhi jurisdictions because Haryana, Punjab, Himachal, Jammu and Kashmir, they'll all file their applications and prosecute their applications at Delhi jurisdiction. So what's an invention? Like as per the section 2(1)(j), generally what we, when we actually come across something very interesting, so it should actually qualify the definition of an invention. So, so you should always try to focus on the definition so that you can come to know what is actually, if what the lead, the research lead, what you have with you is actually an invention. So invention means a new product or a process involving an inventive step. So the word inventive step is very crucial. Like you should try to understand what does inventive step means, right? And of course, it should be capable of industrial application. So that is the prerequisite. If you ask me what are the 3 basic requirements, so it should be a novel, it should be non-obvious, it should have an inventive step, and it should be capable of an industrial application. There should be some industrial applicability of your research lead, or I should say invention. So inventive step, what does that mean? So inventive step is something, some improvement over the pre-existing knowledge, or it could be a form of a step. आपने एक step add कर दिया. For example, you're synthesizing a antibiotic, and the conventional process says step A, then step B, and step C, but you've included another step, which I will call as inventive step, and that should lead in substantive improvement, either in the efficacy or in the productivity or in the economy of the whole process. So the inventive step is something which is an improvement or over the pre-existing knowledge, and that should not be a minor improvement. It should qualify the definition of substantial. It should be substantial either in the form of efficacy or in the form of productivity, or it could be also in the economy also. So the inventive step is very important, because you know that there are many patents which are being granted only for improvements. improving a pre-existing process. There are many molecules which are already known, but the process for synthesizing those molecules can be novel. So you can improve upon the process of synthesizing a molecule and still get a patent. It's not that only the novel molecule will get a patent. The process wherein you are including an inventive step into a pre-existing process, thereby you are increasing the efficacy or productivity, so you can still get a patent, and that step is called the inventive step, and that's what we call as an invention. So invention arises out of fundamental research, and it could also be, as I was telling you, just an improvement over the existing art. So the improvement, I already told you that it could be in the process, in the product, and the applicability. So you can get a patent over that. And thirdly, solving unsolved problems of art or unaddressed issues. Like there are certain problems that the mankind or the different even the animals are facing certain problems. The environmental is being challenged by certain problems. So if you have an answer, if you have a technology to solve those unsolved problems, then also that is qualifies for a patent. And if you have a different approach for uh, solving a problem, that also qualifies for a patent. So what is an invention? Like um, is the invention patentable? These are the different questions which come when we have started drafting an application. So we, as a patent agent, we have to draft an application, and we generally come across different kind of disclosures which come from the university, different faculty members. They provide us with their disclosures, and we have to be very sure that that these are actually patentable. So we do a small study before we take up that invention. That is called patentability study, or we also call it as patentability assessment. We assess the strength of the disclosure, or we assess the disclosure on certain parameters, which we generally check through prior art searching. So uh, to to find out whether an invention is novel or inventive, we generally carry out a prior art search. Because, for example, if you are a scientist who is working on cancer drugs, and I am working on industrial enzymes, so I cannot actually judge what your expertise. So what I will do to actually judge whether your invention is novel or not, so I will take the help of a prior art search. So a prior art search is something which helps us to find out whether your invention or your claimed invention is novel or it is already a pre-existing art. So before drafting any patent document or before going for filing any patent, we generally do a prior art search. And this prior art search is the prior art for any invention could be when we do a prior art searching. That means when we anticipate the invention by means of certain disclosed technology, we also take into account if it is oral disclosure, or because even if it is existing in a community, if the technology or the process or the product, if it is existing in a village, in a community, by means of word also, then also you cannot secure a patent for that. So even the oral disclosure of your invention can make it a prior art, and that also can be an hindrance of for you getting that patent. So the second kind of prior art is the printed publications, which are available to the public. And the printed publications can further be classified into non-patent literature and patent literature. So we as academicians, we generally don't go through patent literature. We generally go through non-patent literature, which includes the journals, the books, the conference proceedings, the web pages. So these all make non-patent literature. Uh, but as a patent attorney, or as a person who has to advise you about the patentability of an invention, I have to also check the patent literature, and that we do through some dedicated databases, which are paid as well as free databases, and we make search strings. We make search strings out of your disclosure. We fish out the keywords which are important for your invention, and based on those keywords, we connect those keywords by certain Boolean operators. I'll briefly tell you about Boolean operators. You might be using these operators before also. So generally, everybody knows Boolean operators are and, or, and not. So these are certain operators which are used for quick searching of your invention. For example, I'll give you an example that if, for example, you have extracted a compound from a banyan tree, ficus, so you have extracted using a methanol, and the methanolic extract of the plant, that is ficus. Let's take the example of Ficus bengalensis, which is a common banyan tree. So, Ficus bengalensis methanolic extract, it has shown anti-cancer properties against colon cancer. So I will make a search string which includes the name of the plant, that is ficus, and what kind of extract it is. It is methanolic extract, so I will include the keyword methanol. Then I will include the keyword cancer, so that I make a search string, and these keywords will be connected through certain operators, which are called Boolean operators. So, for example, I wanted to show you that we have these are, I hope you can see my screen. This is a whiteboard. And, or, and not. These are the Boolean operators which we generally commonly use. And there we go, Boolean operator. So we can use these Boolean operators, and there are these are common operators. And the example which I was giving you, how to make a search string, is that we have to connect these ficus, and ficus is the name of the plant, and methanol, and I can use a word instead of methanol or ethanol. Both are polar solvents, so I will use these both terms in or combination, and then I will combine them with the keywords for cancer, or carcinoma. They make the same kind of a meaning, and we can also use melanoma, right? So this is my search string, if you can see, I have used two kind of operators here, and or. So if I run this search string on a database, for example, I'll show you a database which is accessible in our university, that is called Scopus. So now what you see on your screen is a database which we use to assess the patentability of an invention. I'm just showing you as an example. This database is called Scopus, and you can see that you can do a document search here. You can do author search here. And there's another option which is available, is that if you have a discovery, so you can just type in your keywords in this database, and this will return you possible answers. You can also search by affiliation, means if a person is affiliated to an institute, what all documents are retrieved from that institute. So I'll just show you how the document search is carried out here. So in the document search field, you can see there are many options available under the search field. That is, all fields means full text search, which will include title, abstract, uh, introduction, keywords, even the references. Then another field is title, abstract, and keywords. So this will restrict your search to title, abstract, and keywords. And you can restrict your search to authors also. If you want to search for a particular author, then also you have this option of restricting your search to authors. Then source title means if what is the source of that disclosure. Then article title, you can also restrict your search to abstract, keywords, affiliation name, city, country, funding information, sponsors, and so on. So the example I was showing you, it shows ficus and extract and cancer. So if I carry out a search for this these keywords, and if I press the search button, so you can see I'll be getting some results. So you can see I got 260 document results if I was using and as the Boolean operator. Now I will show you how to narrow down 260. It is very difficult to study the 260 documents, and to find out the novelty of your invention is very difficult. So I will edit this search, and now I will put another Boolean operator, which is called a proximity operator. That is W5. And here also I'm adding W5. So W5 is actually a proximity operator, which will restrict my search to 5 words on the left of cancer and 5 words on the right of the cancer. Similarly, if 5 words on the right of the word ficus, if I find extract, it will be shortlisted. And 5 words towards the left of the word ficus, it will also be shortlisted. So these are called proximity operators. Now you can see the result has further narrowed down. Now I have 8 document results, which are talking about ficus, extract, and cancer. Now, if you want to further narrow down your search, so you can use another proximity operator, which is called PRE, P-R-E. So if you replace it with P-R-E, then you just get 6 document results. So now you can just press this button, show all abstract, and then you can go through the documents wherein ficus, I told you that this is a plant which belongs to the family Moraceae, and it is showing activity against certain kind of cancer. So here I have a document which shows that ficus is used to treat the ovarian cancer. And here I can see that ficus extract has been used to treat anticolorectal cancer. So these 6 documents are the most relevant documents that you should study before filing a patent for your invention. So I'll just summarize what I did. I tried to show you that how to do a prior art search and how to make sure that whatever you are going to file as a patent is actually really novel or not. So that I showed you by using a non-patent database that is called Scopus that our university has subscribed. So the Scopus is actually a database which includes the full text of 19,000 journals and web pages, and many book publishers are contributing their material to this database, that is Scopus. So Scopus is a very good and comprehensive way of finding out whether or not your invention is patentable or not. So I advise each one of you to at least do some bit of searching and literature studies before you actually go out and start saying that this is a novel invention.
Rajiv sir, someone raised hand. Can we take up questions in between?
Yeah, please.
Prayankul, would you like to ask your question? Prayankul, you raised hand. Do you have any questions?
Seems that it was mistakenly done. Yeah.
Mistakenly done. Yes, sir. So please, I'm sorry to interrupt.
Not a problem. You can, in between, if there's someone, you can directly ask me questions. All right.
Thank you, sir.
So this was what I was trying to explain you is prior art study and the importance of the prior art study for filing your patent. So every attorney does this, or every patent agent does this before actually advising you anything about the patentability. Now I get back to my presentation. I hope you can see my screen now. Yeah, so we were here. So the prior art study is very important, and I showed you only through one of the database, that is Scopus. But for patent literature, you use another database, which are dedicated databases, which are paid databases. But there are certain free databases for patent literature study also. For example, Google Patent, European Patent Office, that is for European patents. And for US patents, you have another database that is called USPTO. And for the WIPO applications, which we will be discussing later on also, we have another database which is called Patent Lens. I'll just repeat. For European, we have eSpaceNet. eSpaceNet, that is the name of the database. And for US patent applications, we have USPTO. And for WIPO, that is World Intellectual Property Organization, the patent applications are called WIPO applications. The website name is patentlens.com. And you are all aware with the Google patents also. So you can use all those databases to assess the novelty of your invention. So the information known publicly before the effective filing date of a patent application is called prior art, and it contains the information available in the public, which includes patents and published patent applications. So the foreign patents, if you say, and the published patent applications, they also become a part of the prior art. So while you are doing a prior art study, you have to be sure that you check the the patents of all the countries. So it is not that if you're filing in India, you have to only see that if someone has the same invention in India. A prior art study means, or a novelty is never assessed based on the knowledge existing in a single country. They will check, or the examiner of a patent will check the novelty based on all the published literature worldwide through the databases, through the different databases. So your invention should be absolutely novel, not practiced in any part of the world. There's a sharp difference between the enforcement of a patent. The enforcement of a patent is always in a particular टेरिटरी लाइक इंडिया का पैटेंट है तो इंडिया में ही उसका राइट है लेकिन अगर while assessing the novelty of an invention अगर एग्जामिनर पहले आपका पैटेंट को चेक करेगा ना तो while assessing the novelty of the invention he will not restrict his search to Indian continent. He will he will do a worldwide searching. He will do a worldwide searching to assess the novelty of your invention. So there's a difference which you should keep in mind, that though patents are territory specific, but patents are granted only after assessing the novelty, and the novelty is checked worldwide. And that is, the task is performed by the patent examiner. So there comes the importance of carrying out the prior art study, that you have to check the prior art of all the foreign patents and all the published literature in the form of journals, magazines, books, manuals, catalogs, even the websites. It could be a conference proceedings, it could be manuscripts, review articles, or any scientific paper. Now, before drafting, there are certain checkpoints which we make, like we conduct search, which I just described you, that is called the prior art searching. So that is a routine process before filing any patent. Then once you're sure that there is no prior art existing for your invention, then you start jotting down the points, or the uh, the issues which the pre-existing knowledge doesn't addresses. Okay, so if I talk about for example vaccine against coronavirus, if you say that your vaccine is a novel vaccine, it should be an improvement over the pre-existing knowledge of the same virus. Since this virus came, this is a new virus, we generally don't have pre-existing knowledge about this. What is was available in the literature was that this virus was prevalent in the different animals, and this is a group of virus, but the vaccine was something which came very new, so you won't find any prior art for the vaccine against coronavirus. But as a matter of practice, for other kind of inventions, we generally try to find out what are the different problems that were existing that your invention is now solving. So for example, if you come out with an invention which is a portable bicycle. So previously the bicycles were not carried, they were not it was difficult to shift them or to carry the bicycle. But by inventing a portable foldable bicycle, you actually solved a problem that you can even carry your bicycle up hills and to the different picnic spots. You can carry it to any place. So you have to enlist the problems which were existing in the prior art. So next thing, what is the problem sought to be solved by the invention? So what you should be very sure that your invention, what problem is it going to solve, and where does the novelty lies? What is the novelty of your problem? How it is novel? And you have to be very sure that the solution should not be obvious for getting it patented. And has there any prior publication over that invention? It is quite possible that you yourself have published your findings about the invention. So this is also quite a common problem in academics, that most of the academicians, they are very keen to publish their research work, and in doing so, they lose the patentability. So you have to be very sure that you haven't published the disclosure in any form in the public domain. Then you have to ascertain the type of application, whether you want to go for a complete application or a provisional application. Because at times you have conceived your invention, but you are not really ready with the supporting data to prove that yes, your invention is working. जैसे आपको थोड़ा सा क्लू मिल गया कि हाँ ये जो मेरी ये वाला जो मॉलिक्यूल है, this has antiviral properties. आपको हल्का सा क्लू मिल गया, and that molecule was never known for antiviral properties. Now, in such a scenario, you know that there is a lot of demand for antivirals, and there is a lot of competition amongst different players in the market for to come up with new antiviral compound. So ऐसे सिनेरियो में जब आपको ये पता लग गया कि आपका जो मॉलिक्यूल है that is antiviral in nature, but you don't have supporting data to prove कि हाँ ये वाकई एक्सपेरिमेंटल डाटा नहीं है आपके पास कि ये वाकई एंटीवायरल है, then you can go for a provisional application, जिसमें कि आप अपना disclosure पूरा लिख के and in its complete form with flowcharts, whatever you know about your disclosure, you can file a patent application. And the benefit of filing such a patent application is that you get a 12 months period. आपको 12 महीने दिए मिल जाते हैं to convert your idea or to convert your partial invention into a completely supported invention, or you get 12 months to convert your idea into a product. So ये काफी important माना जाता है, क्योंकि जिस दिन आपने ऐसी एप्लीकेशन फाइल की प्रोविजनल पैरेंट एप्लीकेशन, उस दिन से माना जाएगा कि ये आपका प्रायोरिटी डेट है। मतलब आपके बाद कोई वो इन्वेंशन लेकर आएगा उस दिन के बाद, तो उसको वो इन्वेंशन उसकी नहीं मानी जाएगी, right? So if I go on 1st January 2023 with this invention into the patent office, मैं provisional application file कर देता हूँ, और आप 2 जनवरी 2023 को लेके वही कंपाउंड की एप्लीकेशन लेकर आते हो, तो आपको पैटेंट नहीं मिलेगा, because I was the first one to file this application, right? So there is always a benefit of getting a provisional filing a provisional patent application, because you get a priority date. Right? So the moment you have conceived the invention, you should always try to file a provisional patent application. And later on, you can support your application with all the experimental data and all the supporting diagrams and disclosures and embodiments to actually prove that, yes, you have conceived this invention and the invention is completely enabled now. Nobody can challenge it because you have all the data to support the working of this invention. So provisional applications give you that kind of a benefit. Now, another decision which is to be made is, you can read the last point, beside the area and nature of protection. Whether you should go for a conventional patent application or for a PCT or for an ordinary application. Let me tell you, students, that applications are of different types. We have ordinary application that is filed only in India. We have another kind of application which is called conventional application, which is filed in the countries which have signed the Paris Convention Treaty. So we can file in those countries also. And there is another kind of a patent application which is called a PCT application or a WIPO application, which is kind of an application which can allow you to secure your patent rights in more than 273 countries of this world. Now, before we get into filing process, I personally felt that you should know what is not patentable. So I'll just quickly go through these points. These are very important points because many a times we are confused that whether or not a particular invention is patentable or not. So you should always keep these points in mind while assessing the patentability. So if your invention is frivolous or contrary to well-established natural laws, then it is not patentable. Natural laws means the law of gravity, law of आप बोलते हो कि एक ऐसी मशीन है कि जो gravity को खत्म कर देती है, तो that is not possible, and that we would regard that invention as frivolous. So the thermodynamic laws, the laws and theories of evolution. So all these are well-established natural laws which cannot be challenged or which cannot, any invention cannot be is not possible, which is against these, or which say that these natural laws are not correct or incorrect, or they inventing something which is against the natural laws. Second is any inventions which are hurting the morality and are injurious to public health. For example, a gun is not patentable. A weapon to kill is not patentable. A compound, a poison is not patentable. If you say that, okay, I have come with the compound micrograms, so such kind of things are against the public morality, and such kind of things are not patentable. Scientific principles, abstract theories, and new property or use of known substance. For example, if you say that paracetamol also has anti-cancer property, so that is not patentable, because paracetamol is a known compound, its structure is known, but you have discovered another property of paracetamol, so it is not going to be patentable. Mere admixtures and processes thereof. So just you are combining the salts, the esters, the polymorphs, or the different compounds. So such things which are just a mere admixtures, they are also not patentable. जैसे आपने एस्पिरिन और पैरासिटामोल को मिला दिया तो उससे एक नया इफेक्ट पैदा हुआ, so that will not be considered as a invention because it is just a admixture. You are combining analgesic with a painkiller, so or a paracetamol which is antipyretic. So you just are not making an invention just by combining different molecules into one tablet. So that is not patentable. So similarly, mere arrangement and rearrangement of known devices, each functioning independently of one another. So making a solar panel से आप आटे की चक्की चला रहे हो और आटे की चक्की से आटा बन रहा है, तो such kind of a thing, you just these are all independent known devices. आजकल फोन में you see there's a camera, there's a FM radio, and there is also you can see many other features. You can measure your BP. So this doesn't qualify. Your phone doesn't qualify for a new invention because they are just mere rearrangement and arrangement of known things. Camera भी known है, FM radio भी known है, और जो different apps हैं उसमें installed हैं वो भी known है. You are just rearranging these apps. That doesn't means that you have invented something new. A method of agriculture or horticulture that is also not patentable. So in India, a method to grow a crop is not patentable because here the farmer is very poor, and if somebody is granted, just imagine a method of growing crops, so he will be having a monopoly over agriculture. So that is not possible. So in India, we don't give any patents for a method of agriculture or horticulture. Similarly, a method of treatment. Doctors को भी हम कोई patent नहीं दे सकते कि इन्होंने इसका इलाज कैसे किया. So method of treatment of human beings, animals, and diagnostic methods, इस पे कोई patent नहीं दिया जाता इंडिया में. Right? इंडिया में बोल रहा हूँ. It is quite possible that patents are given in US over the similar thing. For example, breast cancer ki kit pe a patent was granted in US, but the same company when it approached India, उनको वो patent नहीं दिया because हमारे यहाँ पर a method of treating a human being or any diagnostic method is not patentable. So the laws also vary from country to country. कोई चीजें यहाँ patent नहीं हो रही, वही चीज दूसरी country में जाकर आप patent करवा सकते हो. So plants and animals in whole or any parts thereof are not patentable. Any biological process is not patentable. Mathematical or business methods, computer programs are also not patentable. So computers वाले जो लोग हैं, they do write different languages, computer languages, in the form of algorithms, and these algorithms are not patentable. Similarly, mathematical formulas, a method to perform a business, such kind of things are not patentable. And literary, dramatic, musical, any artistic work, they all fall under the other kind of a patent right that is called copyright. So they can take a copyright, but not a patent. So this slide was important because you should know what cannot be patentable. Now, what is public domain? Because I told you before that if your invention is in public domain, you cannot get a patent over that. So what does public domain means? So public domain का मतलब होता है कि वो आम जनता में उस बात का किसी को पता ना हो. So the public knowledge known to a person in the art, a part of the mental equipment of those concerned in the art under consideration, and it should not be available in the common general knowledge. That means all available public knowledge and all that is published. So publicly वो नहीं पता होना चाहिए और published literature में भी वो चीज नहीं होनी चाहिए. So that all makes a public domain. So books, theses, any kind of conferences, they are all comes under public domain. So similarly, publications and any kind of presentation of that work into a public gathering should be avoided to make sure that your invention is known. Now let's talk about patent. specifications. Specification means when you write a patent, the complete text is called patent specifications. So before you are granted the patent, these specifications are being checked and read by the patent office. And also, if you, after the grant of your patent, if anybody is interested to take a license of that technology, so your licensee or your assignee, they will also be going through the specifications to know how much strength does your patent has, right? So if your invention is prosecuted, or there is some infringement case, then also your specifications are read and judgments are made based on those specifications. And any technical peer and skilled persons, they will also read your specifications. Your competitors, yeah, there's a webinar going. So your competitors and your all the commercial players who are competing with you over the similar technology, they all will study your patent specifications, and the general public also. So there lies, I'm showing you this slide because patent specifications should be very thoughtfully written so that your patent holds a lot of strength. Nobody can challenge your patent. For example, you saying that ficus is showing anti-cancer property. So your specification should include all those experimental data which are required for completing supporting your invention in all the aspects. So that is very important that you actually uh, enable your invention by showing your all by showing all the supporting data that you have. Now, the specifications, if I talk about the patent specifications, so again, depending on whether you are filing a complete patent application or a provisional application, the specifications will vary. So here, if you see the specifications, they actually vary if for provisional and for complete patent application. And also, what kind of application have you are filing? What kind of applications are you filing? So is it a conventional application? Is it a PCT application? Or is it a divisional application? Or it is a patent of addition? So these are different kind of patent applications which are being filed, and the written part or the specifications vary as per your requirements or as per your uh, choice of application. Now, as I told you that if your experimental data is not completely supporting uh, your application, so I gave you an example of provisional patent application. You can go for a provisional filing. So in that case, your specifications would be just a disclosure in the form. It can be in the form of a paragraph also. And but what we do that we completely disclose whatever matter we have pertaining to that invention in the provisional application, because at the time of filing of complete application, means after 12 months of filing the provisional application, you cannot add new matter to it. So you cannot add a new finding to that. So whatever you have secured the priority date before, you have to stick to the same matter. You can just support that matter with experimental data, but you cannot add fresh matter. So a provisional application should only be filed when there is an urgency and you have to show your product to some other company for getting for taking the for selling your invention in the form of a license, or you are planning to submit your thesis, because thesis is a public document. अगर आपने अपनी thesis submit कर दी तो वो public domain में चले गया, तो आपको thesis submit करने से पहले ही you have to secure your patent over it, if provided you have something very novel. Then sometimes you're working in a research group and you develop a new technology, and one of the group leaders or uh, one of your colleagues amongst the team is leaving that company. So in that case, you have a good chance of leaking of the technology. In such a scenario also, you have to quickly go for filing a provisional patent application. Then accidental disclosure means you can, by mistake, disclose your invention in front of other people whom you are not intending to disclose. But in that scenario also, for example, आपने जोश जोश में किसी को अपनी सारी invention disclose कर दी, तो और वो आदमी हो सकता है वो भी किसी R&D lab से ताल्लुक रखता हो, या वो ये आपकी invention का जो डिस्क्लोजर है किसी और को आगे जाकर बता दे, तो उस कंटेक्स्ट में भी यू शुड इमीडिएटली गो फॉर अ प्रोविजनल patent filing. And of course, if there are many competitors of yours for a particular technology, then also you should think of filing a provisional patent application. Now, what are provisional specifications? So that means complete disclosure as much as possible. It doesn't has any structure. If I say about structure means उसमें ऐसा कुछ नहीं होता कि पहले आपको field of invention लिखना है या फिर introduction देना है या background लिखना है, उसमें claims नहीं लिखने होते, उसको बस एक आप you can just make a 2 or 3 page document wherein you are disclosing complete of your invention. And one thing is sure that you since you cannot add new matter later on, so you have to disclose whatever you have in its completeness. So so you get just 12 months for filing a regular patent application after completion of 12 months. Now, the other kind of specification is a complete specification, जिसमें आप you don't file an incomplete thing, which is in provisional. So it's a techno-legal document describing and specifically claiming the invention. So this is done when we disclose a complete specification, that is in Form 2, and it starts by the preamble. The following specifications particularly describe and asserting the nature of the invention and the manner in which it is to be performed. After that, your invention disclosure starts. There are two broad categories in which you can separate your specifications. That is, one is description and the other is claims. So description is something which is written to enable your claims. So whatever you are claiming should be completely enabled in the description. If you're saying that I have an antiviral compound having this structure, so in description part, claim में तो आपने लिख दिया a compound with a structure this having antiviral property. For example, this is your claim. Now this claim has to be supported with all the experimental data in the description. तो description में आप ये पूरा लिखोगे कि क्या क्या एक्सपेरिमेंट आपने लगाए टू प्रूव दैट इट इज एंटी वायरल इन नेचर, क्या क्लिनिकल स्टडी आपने करी, कितने उसमें आपके सब्जेक्ट्स थे, और कैसे आपने ये कंक्लूड किया कि दैट दिस कंपाउंड इज एंटी वायरल। तो आपको क्लेम्स और डिस्क्रिप्शन में डिफरेंस ये है कि क्लेम्स आर समथिंग which define the boundary of your invention, and but the prerequisite for any claim is that uska complete enablement yani complete support should be there in the description part of the inventions. So a complete specification shall fully and particularly describe the invention and its operation or use and the method in which it is to be performed. It should disclose the best method of performing the invention, which is known to the applicant and for which he is entitled to claim protection. So specification should be a complete disclosure. Even आपने क्या pH use किया था, कौन सा salt use किया था, कौन सा buffer use किया था, buffer के ingredients क्या थे, और everything should be disclosed in the specifications for completely enabling your invention. And what is the best part, the best method of performing, or there should be a best method or the best way of performing your invention. यानी किस तरह से आप अपनी इन्वेंशन को परफॉर्म करते हो, उसका बेस्ट मेथड आपको डिस्क्लोज करना पड़ेगा. That is the optimal conditions for performing your invention. So description must describe the invention comprehensively, should fully explain the problem to be solved with examples. No, there should be no ambiguity. There should be no confusion. And it should be adequate and sufficient so as to enable a person skilled in the art, we call it as posita. Person ordinarily skilled in the art should be able to perform it or to reproduce the same results without any inventor's input. तो इतना डिस्क्लोजर हमें चाहिए कि कोई भी आदमी उस इन्वेंशन को प्रैक्टिस कर सके completely. So a description completely reflects that your invention is novel and it is inventive and it has industrial application, and that makes it patentable under the patent law. Now, I've been talking about the description, but let me tell you the description is a structured document. It's a complete structured document which has certain parts, like you might have seen or read papers. So a paper also has structured parts, like title, then we have abstract, we have introduction, so and so on. So a description, a patent description also has certain parts which we call it as the structure of a patent. So it includes the title, it includes the field of invention, it includes the background of invention, it also includes the prior art details, it includes the objects of invention, statement of invention, then detailed description of invention. So these are the headings under which you structure your complete description. Okay. So title, field of invention, background, then we give the prior art details, then we say what are the different objects of the invention. That means the objectives, why your invention is so important and what all can be solved by your invention. That all comes under objects of invention. Then your statement of invention, that this is a drug which has antiviral properties. This is a statement of invention. Then detailed description includes all the experimental data. So let's see one by one of each of these fields. What is the importance? So titles should be very concise. It could be a single word also. So you are never disclosing the invention in the title The titles are in minimum words and it includes the crux of the invention. And it never discloses the invention in the title. You never disclose your invention in the title. Then it could be a product, it could be a process, it could be an apparatus, the title. So avoid using conventional words. For example, if you've invented a novel brush, you don't call it as a brush, you call it as a cleaning article, right? Because cleaning article means it's a broader term and it includes anything which is having a appearance of brush. So a pen would be called as a writing instrument. So when you are writing the title, if you have a pen with which can write with multiple inks, so you will say that a writing instrument capable of writing in multicolors. So you never restrict your invention in the title. You are always trying to claim all the articles falling under the category of brush. So you always will prefer to write cleaning article instead of brush. Then field of invention means you have to provide some more details and the utility of the invention. क्योंकि ये second topic है, after the title you write field of invention. So it provides the utility. Sometimes it is used as a tool for search in the absence of abstract. किस काम आती है and वो क्या है? Then comes the background. It provides a technical background of the invention. It says that how your invention is solving different problems which were not getting solved prior to your invention filing. Then you write about the prior art in the background section. It is a brief write-up of what is known before the invention. Means क्या चीजें already उसी invention के बारे में हमें already known है, and how does your invention is technically superior to the pre-existing prior art. So prior art should include unsolved problems, prior art solutions which are not working, describe new solutions, and adequately describe all those solutions which are provided by your invention. Then comes objects of the invention. So it will go like it will say that one of the objects of the invention disclosure is to provide an antiviral drug for the treatment of cancer. Then you can also have an ancillary objects, like further that another objective of the invention is to have a economically and technically superior drug against the virus. So on, you keep on adding other ancillary objectives to your main objective. Then comes the statement of the invention. Like it's a statement like what is your main claim? What is your verbal agreement about your invention? So that becomes the statement. It is essential only when there is an omnibus claim. Then detailed description of invention. It sets out the best method of performing the invention. Means किस condition में आपकी invention सबसे अच्छा काम करती है. So you have to give the complete disclosure for that. So it describes the invention in greater details with examples, illustrations, graphs, and diagrams. So description should be sufficient to enable a person skilled in the art to completely reproduce that invention or to practice that invention. So claims are of two types, independent and dependent, and they define the essential features of the subclaims, and we have many additional features can be taken up in the dependent claims. So they are the important and the property of a patent is your claims, and they shouldn't be merged into other claims. So a separate claim has to be formed for the important features. So if I say an antiviral drug having a particular structure which is derived from ficus plant, so another feature of this invention is that uh, that the the methanolic extract of the plant is working as a antiviral compound, and that too that extract from the bark. So in the dependent claim, I'll be writing the antiviral compound of claim 1, wherein the active principle is extracted from the bark of the plant. So there is a independent claim. Then there are claims which are dependent on the independent claim. But these independent claims, they have an essential feature. यहाँ पे essential feature क्या था? कि methanolic extract of the plant was having the methanolic extract of the bark of the plant was having anti-cancer property. So this was claimed in the dependent claim. So this is how you structure your claims, and you have to be very tricky in writing your claims, because you have to claim as much you can, but within the boundaries of your patents. And what defines the boundary of your patent is your specifications. Because if you are not enabling your claim, आप बोल रहे हो कि इसमें एंटीवायरल भी है और एंटीपायरेटिक भी है, एनाल्जेसिक भी है, बट डिस्क्रिप्शन में तुमने सपोर्टिंग डाटा दिया ही नहीं, तो आपका क्लेम यहाँ पे रिजेक्ट हो जाएगा. Your claim will be rejected, and claims are actually the legal part of your patent. So you cannot have any right of a compound which is having similar property if your claim gets rejected. So it is the operative part of specifications, claims, and defines the monopoly to be conferred by the patent. And it defines the needs and bounds of the invention at the time of infringement proceedings. Infringement is something if someone is and deriving commercial benefit using your invention, then that person or that firm is infringing your patent. आपको एक प्रोसेस का पैटेंट ग्रांट हो गया कि आपने फाइकस से के बार्क का मेथनॉलिक एक्सट्रैक्ट निकाल कर आपने एंटी कैंसर कंपाउंड एंटीवायरल कंपाउंड बनाया, बट there is someone who has stolen the process and using the same process, so that person will be infringing onto your process, and you can take that person to the court because he is using the same process for making a drug for which you have already been got a patent. So you have to also keep an eye over other firms, that how they are deriving commercial benefits out of your invention. So I'm skipping a few slides so that we come on to the main slides quickly, because we are left with 10 minutes more. So in a chemical invention, you have to be very sure that you have to be very much able to describe the starting materials and the steps of the process and various parameters involved in each step and the end product. So if it is a process pattern. And the proportions are very important here when you are working with different chemicals. So you should be providing a broad range and broad range of chemicals. जैसे आपने बोला कि इस reaction को हमने pH 4 से 5 के बीच में कर सकते हैं, 4 से 6 के बीच में कर सकते हैं, rather than by saying exactly the pH in which you are performing that reaction. So that way you are broadening the scope of your invention. So all the oxidants, specify the class and specific chemicals used. It is a prudent practice, like if you're not to name the exact thing. For example, if it is an acid, you can claim it as all the oxidants that would enable the invention, that all alkali or acid that would help to work the invention. So you can broadly claim it as an acid or an alkali rather than by naming that particular substance. अगर आपने बोला कि ये HCl से ही होता है process, तो इसका मतलब है कि अगर कोई वही process H2SO4 से कर देगा, तो you cannot take him to the court कि हमने आपने जी हमारी invention use की है. This cannot happen. If you are using a broad term like this process should be carried out by an acid, so all the acids will be coming under your claim, and the breadth of your claim will be broader. And this is what every attorney tries to do, that the claim should have a good strength. It should stop others entering and practicing the same invention after reading the disclosure. So claims, I told you that there are two types, and dependent and independent, and they have to be very carefully written so as to make sure that your area or your breadth of your technology is protected from others. Now we'll briefly see, actually Amrish sir also described about the whole process, so I'm skipping these slides. So examination reports are something which do come after filing of your patent, and in this examination reports, the examiner will highlight all the cited prior arts which are similar to your invention, and that needs to be addressed very properly. And you can see this is an examples of examination report which says that claims are lacking novelty, inventive step in view of the cited documents. So the examiners always, they never again, but they will always sit in their own offices and they will challenge your inventions. They will say that ye invention to already known hai, and this is the prior art which is already existing in the literature. And then you have to reply back to the examiner saying that no, how your invention is different from the existing prior art. अब यहाँ पर इस एग्जामिनर ने दो पैटर्न साइट करके दिए हैं जो कि इस की नोवेलिटी को किल कर रहे हैं. अब इसके रिस्पॉन्स में इन्हीं दो पैटर्न्स के हमें we have to defend ourselves saying that how these patents are different and how our invention is different from these patents. So this is how the whole process goes on, and you have already been described about the process to and the complete examination and the grant process. So with that, I would like to describe about the PCT system lastly, which is a, so if your invention is having a utility worldwide, then you can go for a PCT application. You can enter the national phase of any country by opting this method of patent filing. So PCT is for protecting in multiple countries, and it's an answer to many international patent. It's not a international patent, but it is an application, and that application can be prosecuted in multiple countries. So the PCT is always the recommended way of filing a patent when your invention is of importance to the whole world. Like, for example, if you have a vaccine, against coronavirus, then you should always go for PCT application so that you can enter the territory, or you can file your invention all over the world who have signed the treaty. So that's all from my side. This is where I come from. This is my department of microbiology, and it was wonderful talking to you. And now I open the dais for any questions.
Thank you very much, sir. Indeed, an insightful session. So, any queries, participants, you can put your queries in the chat box. Meanwhile, we are sharing a feedback link. So, as I told you in the beginning of the session, it is mandatory to give the feedback as well as the assessment quiz. So, any questions before we go ahead?
Yeah, it was a kind of a revision for them because
No,
the
sir,
primary
both
also.
the sessions were put very differently and were really interesting. And you can see from the participants' feedback that is coming in the chat box. Everyone is really praising the sessions. They were quite informative.
Thank you so much, everybody.
So since there are no questions, the feedback link is just, we'll paste it in the chat box in a while and you all can attempt the feedback. Meanwhile, I'll request Dr. Kumud to deliver the vote of thanks.
Yeah, thank you, Chitra ma'am. So like a very good afternoon to all of you. The impact session has been really very interesting and informative. We started in the morning and we're ending here in the noon. So the credit of this event goes to many people here, which I really need to thank to. First of all, I'm really thankful to all the audiences and delegates who have been listening to these sessions patiently and who has really made the event a success. And I would like to thank on behalf of my event coordination team, Dr. Vanda Arora Sethi, Group Director here, Dr. Chitra Gupta, Dr. Lalit Tyagi, to the AICTE MIC for providing us the opportunity to conduct this event. I would also thank management of Lloyd Group to provide us the support. And needless to mention, my IT team led by Ms. Preeti and social media team led by Ms. Renuka, who had been taken care of. And obviously in the last, again, I would like to thank all the delegates who made this event a success. Rajiv sir, thanks a lot for being part of this and giving in such an insight. It was really, a very, very thoughtful session. I mean, each and every minute thoughts which come to a researcher mind are really sorted out, I suppose, and the feedback will tell it. So thank you, ma'am.
Thank you, Amrish sir, and thank you, Rajiv sir, once again for connecting to us, and all the participants for being patient listeners and being with us for last 3 hours. So that brings us to the end of the session, and it's all about out of the box thinking. I believe IPR is all about out of the box thinking. And as our late President APJ Abul Kalam said, that if you fail, never give up, because fail itself means first attempt in learning. So my message to all of you will be that keep on trying new things and try IPR also, and keep going ahead. So we'll very soon share an assessment link with you, and you can attempt that assessment along with the feedback. Please make sure that you submit within next 10 minutes, and so that we can send you the scores and your e-certificates. So thank you very much, sir. Rajiv sir, one thing is pending on my part, your certificate, your e-certificate. Let me just share my screen to acknowledge your session. Thank you, sir. Thank you very much. We'll be mailing this to you.
Yeah, this is beautiful.
Thank you so much, sir. So we hope to see you again, and this time in offline mode at our campus for some session.
Yeah, definitely. I look forward to it.
Thank you very much, sir.
That's really good. Thank you to the entire team for such a wonderful opportunity and giving me an opportunity to speak to such a wide group of people. Thank you.
Thank you, sir.
Thank you, ma'am. Thank you.
Thank you, sir. So participants, we are still there and we'll keep the session on till you submit your assessment quizzes. We'll post the assessment quiz link here itself. So it has already been posted. So kindly attempt your assessments as well as feedbacks and submit them. Thank you very much, all of you. Five minutes. Yeah.